private companies across industries, including but not limited to aviation, banking, ports, finance, real estate, healthcare, and others. And a common concern that foreign companies bring to us is how do we engage with labor relations and trade unions, and how do we foster better industrial relations? So our advisory services include advice on labor laws, and we have significant experience even on the litigation aspects and dispute resolution aspects of labor relations. So we look at handling disputes from these companies and manufacturing units and other corporations across the judicial hierarchy of India, right from the district courts up to the Supreme Court of India. In this context, COTRA has informed us that Korean companies also face similar issues with trade unions, and they wish to know how they should engage with them better to foster better industrial relations. And therefore, today's topic is trade unions and collective bargaining in India. So just to understand, a trade union is any combination of people, whether it is a temporary or permanent organization formed for the purpose of acting as a link between the employer and the workers and the employees. So this is typically found, traditionally it was found in manufacturing units. Now it is found in several industries. I see there are people from the automobile industry, and now unions have started affecting automobiles, the software industry, insurance sector as well. We'll come to that. The dynamic between workers and industrialists or factory owners went through a paradigm shift with the growth of industrialization. So this tension and conflict of interest between the interests of workers and the factory owners led to the need for a platform for workers to express their needs. Therefore, the trade union in India, the trade union movement in India began after the end of the First World War, since there was a need to see a coordinated level of activity amongst individual unions. So therefore, we have seen a huge growth in trade unions over the years. At this point, we see that there are 84,642 registered trade unions and several unregistered trade unions. At this point, it is relevant to mention that although there is no legal mandatory obligation on any trade union to be registered, it is always advisable to do so, as a trade union then becomes a legal person capable of suing and being sued, holding property, etc. If you look at the definition of the trade unions, it talks about regulating relations between the workmen, the employers, and the relations between the workmen with the workmen as well. The importance of trade unions is about to grow, since India is adding about 12 million people to the working population every year, and the proportion of the working age population is expected to go up to 65% by 2036. So in India, the first registered labor union was the Madras Labor Union, which is now in Chennai. And this was formed in the year 1918. Subsequently, the general secretary of one of the biggest trade unions at a national level, a centrally recognized trade union, the All India Trade Union Congress, recommended through a representation that a legislation should come about, and that's where the birth of the Trade Unions Act took place. So the formation of trade unions comes from a collection of many laws, starting from the Constitution of India. So the Constitution of India guarantees the right to freedom and expression, and from that flows the right to form associations. And therefore, this is an enabling provision. In a case, T.K. Rangarajan versus State of Tamil Nadu, it was held that the right to strike is not a fundamental part of the right to form associations. So while there are freedoms, there is a corresponding duty imposed upon the state to impose reasonable restrictions on such associations. So the members have the right to meet, they have the right to move from place to place, they have the right to discuss their problems and propagate their views. and also hold property. Then we come to the Industrial Disputes Act. This act regulates the rights of employers and employees in the settlement of industrial disputes in any industry. Please note that the Industrial Disputes Act only provides benefit to registered trade unions. If your trade union is not registered, then it cannot come under the purview of the Industrial Disputes Act. So here we look at, when we look at collective bargaining, which we will explain later, which is when the workers bring forth their points and the employers bring forth their points and collectively they come to an agreement. Then as per the IDA, this settlement is then binding upon the parties. Then we come to the Trade Unions Act, which is the most important act for today. This act was enacted for the purpose of governing and protecting trade unions. So here we look at the process of registration of trade unions and the recognition of trade unions, but we also look at the significant difference between registration and recognition of trade unions. It is possible for your trade union to be registered, but unless it is recognized by your employer, it is of no value to the workers in the trade union because their interests shall not be represented. This is something that the law is still looking at, a formal process of recognition by employers. So while all workmen, interestingly, have the right to form a union or refuse to be a member of any union, not all workers' organizations are treated as trade unions. So therefore, when we look at trade unions, it is important for them to be recognized, even though they are legal. Public sector enterprises recognize trade unions, but in the private sector, there is still a reluctance to recognize trade unions, also because manufacturing units and other industrial units have seen years of trade unions coming about. And in the private sector, in the automobile industry, in the IT sector, we are seeing this growth of trade unions now. So one major danger is that it is a double-edged sword, is that trade unions are affiliated to political parties. So what happened in the initial years was that these workers needed patronage. So when they looked at outside assistance, they found assistance from political parties. So many times the agenda of political parties is pushed through these unions instead of actual problems that the workers face in terms of wages or better working conditions, health and safety, and so on and so forth. So in India, labor law, since we have discussed in this series time and again, is labor law is a concurrent subject. So this means that the central government as well as state governments can enact laws to regulate it. Now, there are 12 central trade union organizations, and these have certain criteria. There have to be more than 500,000 members for them to be recognized as central trade union organizations. But there are many other trade unions as well, which are at a state level or at an individual level. The manufacturing sector in India has seen a lot of unions, and courts have upheld the right of workers to form or join a trade union in India. So the last mile is connecting it to recognition by the employer. When you look at the differences between recognition and registration, it is important for, let's talk about recognition first. It is important for a trade union to be recognized so that the employer can formally engage with them on a plethora of issues. Recognition ensures a clear platform for both the employer and the worker to bring about their issues. Registration of trade unions is optional, but it has its inherent benefits. Why? Because once a trade union is registered, it becomes a legal person. When it becomes a juristic or legal person, it has the capability to sue, to hold property. It can be sued as well under the law. It can be penalized under the law. And it is a legal person, which is treated very differently under the law. And registration of a trade union doesn't particularly mean that it has also been recognized. It is advisable to have both. for any trade union to be effective. For employers also, this is entirely in their court. They need to recognize trade unions and legitimize them, and so that no other agendas can be pushed and industrial progress is not stopped. So here, now we look at the fact that for registration, it is important that the registrar looks at the minimum criteria. The minimum criteria for registration of any trade union is that 7 members should subscribe to the rules of that trade union. This rule is so that trade unions are encouraged, so that workers' rights can be represented and there can be a middle ground formed. It is also important that at least 10% of the workers, or 100 workers, whichever is less, and are engaged as part of the organization, must be members of the trade union at the time of the application. The registrar does not have the responsibility of the trade union which has applied for. All it needs to do is see the technical requirements. If the technical requirements are met, the trade union must be registered. If it is not registered within 3 months, an appeal can be filed to the High Court under the inherent powers and the inherent jurisdiction of the High Court as granted by Article 226 of the Constitution of India. So there is no law at the national level for the recognition of trade unions. However, this proposal is being considered to make a formal process and set it in place so that it becomes easier for both parties. Some states, however, have, like I said, you can enact laws at the central level, national level, and the state level. Some states have set forth principles and rules for the recognition of trade unions, which are Maharashtra, Orissa, Kerala, and West Bengal. So if your organizations are in any of these jurisdictions, it is important that you look at this rules set out by the state as well for the regulation of trade unions. And also, at this point, the onus of or the responsibility for recognizing a trade union lies mostly in the hands of the employer. So as we have seen through the process of the webinar so far, trade union is a permanent body. It is formed on a continuous basis. It is an organization formed by employees or workers, and it achieves its goals through the collective action of many. When you look at the objectives are primarily 5: securing better wages, securing better health and safety working conditions, securing a good chunk of the profits that the employers make through bonuses. This is a double-edged sword for industries which want to grow. Trade unions also tend to block schemes which improve automation, and because they are scared that the trade union workers will lose their laws. This is a moment of conflict because you cannot grow unless you automate, and they won't let you automate with stopping progress by going on a strike or a gherav or a go slow movement. So here we look at organizational stability and leadership, and this can only come when there is a consensus in the thoughts and representations by the trade unions and the employers. So it is important for employers to recognize those trade unions where they trust the representatives of the trade unions to be reasonable. So this is a platform to workers. This will promote congenial industrial relations. And in recent times, however, we have seen that although there is a merit in trade unions and they help workers, they also benefit employers in many ways. However, when they engage in strikes or aggressive acts, major losses are caused to businesses, and therefore it is important to find a common ground. With that, we come to collective bargaining. And collective bargaining is a process by which the workers and the employers come together to agree on certain key considerations which have been pointed out before, such as salary considerations, social benefits, grievance redressal, in addition to the other once mentioned earlier. So an organization may make these decisions on their own, but of course, because there are workers and they have their own set of rights which they feel are being impinged upon, they may have a problem with what policies are made, which they feel tend to be in favor of the employers and profit, and not in the interest of the workers entirely. So here, a collective bargaining agreement is very useful. It is a technique by which the disputes regarding the conditions of employment are resolved in a very harmonious and amicable manner. The process is very clear. However, its implementation becomes quite complicated. A charter of demands is presented by generally the workers, but it could also come, some suggestions could also come from the employers. On this, there is a discussion and then a proposal from one of the parties. From here, we go to the stage of negotiation, where both parties sit together and put forth their points. And then that is crystallized in a collective bargaining agreement. If the workers don't agree to the terms and they feel that the collective bargaining agreement is not in their favor, they go on strike, or they employ some of the other functions such as stopping production, or not coming to work, or stopping the mill from working or the factory from working. And ultimately, there is a conciliation. But as you can see, there is many slip between the cup and the lip. Sometimes on paper, this works, but in practice, it does not work. So there are various types of collective bargaining agreements. There is a national level industry bargaining, which is in core industries where the central government is the employer, such as banks, coal, steel, ports, docks, oil industry. So here there is a coordination committee that is set up by the government, and this engages in the collective bargaining proceedings. And if the state and the central governments disagree, there is a problem here. So if there is, say, a different government at the center and a different government in the state, sometimes they may disagree, and this may cause major loss to your business. Therefore, it is important to understand these concerns and factor them in while formulating your policies and your agreements. So at an industry level, industries dominated by the private sector, such as cotton, jute, textiles, tea plantations, etc. Here, the bargaining occurs in two stages. One is at the company-wide agreement level, and the second is at the regional level, at the plant level. So here, basic wage rates and other benefits are decided at the company level, while allowances, incentives, holidays, etc. are decided at the regional or plant level after considering the needs of the employees. However, such regional agreements are only binding if the employers association authorizes it in writing to bargain on its behalf. Then we come to the last type of collective bargaining agreement, which is the enterprise level or plant level bargaining. Workers prefer this because they can negotiate better rates, and the paying capacity of the company is higher in such cases, and labor issues can be easily resolved. In a decentralized plant level bargaining, there might be a tussle between the management and the workers if there is a failure from on the collective bargaining agreements have their advantages as well as their disadvantages. About any change, since the trade unions speak on behalf of all of the workers collectively, they don't have to individually work with each worker and ask them their issues. They can collectively bargain for better wages as a collective unit, and this helps the workers. The workers can make their voices heard at such a platform provided by the union. The workers feel a sense of belonging, sense of security, and the social security requirements of the members is met. As you can see, all labor laws, as we have discussed in this series, are all built on the basis of social security for the workers. The demerits or the disadvantages of trade unions and collective bargaining agreements through this are that if there is a failure in negotiation, it may lead to a strike or a lockout. If they don't see any immediate reward, trade unions may not welcome the improvement in technology or rationalization or improved methods of production, because they have this fear that their workers will be out of work. So therefore, a strategy needs to be laid out as to how to placate them and say, okay, your workers will be trained to do something else if she important, because it is important to get through to them. There is a difference in the level of education and understanding. So that gap has to be bridged by the companies and the manufacturing units and industries. Sometimes extreme losses are caused to the community, to the company, to the location, to the nation as well. Worker does not want to join the trade union, they may not allow that worker to get a job, and that may cause a rift even if they are deserving. Now, the problem with the collective bargaining and collective stance being put forward is the Yes. So here we look at the recognition of trade unions, and this means that employers should engage in discussions which affect workers and their rights to foster better industrial relations. It is important for the employer to be on board with the representative chosen by the trade union. Therefore, the recognized trade union that the employer engages with needs to be recognized with care. Traditionally, trade unions were limited to the manufacturing sector, but now, in recent years, we have seen that other sectors are being affected as well, and therefore these need to now gear up and factor in their strategy to deal with trade unions in consultation with employment lawyers at Surya and Company, to be able to get this strategy in place before they engage in any dialogue with the workers. So now, as you can see, in the automobile sector, there were strikes at the Honda Motorcycle and Scooter India in a couple of years ago, and then there was also a fall in production at the Maruti Suzuki plant because of trade union-backed violence. Most of this centers around wages and other social security benefits. In the power sector, there are labor reforms which have been introduced relating to privatization and denationalization. So e-auctions of coal and the introduction of the Coal Ordinance Special Provisions Bill caused union strikes at Coal India Limited and Singareni Collieries Company Limited, as this was seen as a disruption by the unions. The insurance sector is seeing unrest because of reforms regarding hike in FDI and disinvestment. This may not affect Korean companies so much, but it does have a tangential effect on all companies because insurance is linked. And from the information technology sector, we see that this is the first time we're seeing that in the software industry, there is a union being formed. And this happened because as an example, the Tata Consultancy Services saw some backlash from trade unions when they terminated the services of some of their employees. So trade unions are very powerful tools of change, and they have to be recognized and they need to be worked with to bring about effective change. This brings us to the culmination of this webinar today. And as we see, trade unions are important organizations for the development of the country, as it is a democratic development, and it puts the needs of the workers forward. And that's important. Collective bargaining is also an important aspect of employer-employee relationship. However, we must bear in mind that it is only given to those trade unions which are recognized. The demand for mandatory recognition of trade unions has not been provided under the Trade Union Act. However, this has been raised time and again by workers' organizations. Today, the growth of media has resulted in the empowerment of trade unions, and they have turned into an influential pressure group in not only in the manufacturing sector or industrial sector, but also in the agricultural sector and allied sectors. So trade unions have always had two faces. They are the sword of justice and vested interest. The balance between these two is extremely important. And in many countries, unions have now emerged from their traditional roles of conservative institutions, and they now look at benefiting both the employer as well as the employee. They don't look only at one aspect, because most of them have also realized that to grow, they need to have a healthy dialogue between the employers and the employees to facilitate better industrial relations. Thank you very much. Kamsa Hamida, and thank you.
Thank you, Ms. Matt.